Suppose a district court issues a judgment that is void ab initio, and the party against which the judgment is entered waits a year before filing a notice of appeal. Would the Court of Appeals be obligated to entertain that appeal?
I think it would, Your Honor, because at that point the appeal, the filing of the notice of appeal is tantamount, or is not tantamount, would require an appearance before a court and would result in the appearance before the court would result in submission to the jurisdiction of that court.
I mean, that does seem to be the logic of the idea of a judgment being void ab initio, and we addressed that last term in Hewitt versus the United States. Not a case that it's a criminal case, but still, we talked about void ab initio, and we said if a judgment is void ab initio, it's as if it never existed. It was erased from the historical record. So what you're saying does follow from the logic of that. But doesn't it seem strange that the appellant would have an unlimited amount of time to appeal from a judgment that's void ab initio?
I think even a void judgment can be given effect if the defendant or the judgment debtor acquiesces to the court's jurisdiction. And so if, for whatever reason, the judgment debtor believes that there is no basis for the appeal, the filing of the notice of appeal establishes jurisdiction and results in a waiver of the opportunity to file a Rule 60b-4 motion.
What about fraudulent judgments? Do you think that they can be challenged at any time as well, or there's no ground on which they can be reopened?
Well, I believe fraudulent judgments are covered by Rule 60b-3, which requires which must be filed within 1 year. And so that timeliness aspect applies through Rule 60c-1 as well as Rule 60b-3.